Good afternoon. My name is Bruce Adelson. I'm an attorney in the Washington, D.C. area, and I'm a former U.S. Department of Justice Civil Rights Division senior trial attorney. I'm coming to you today on behalf of Bromberg and Associates. I wanted to continue our dialogue about the new healthcare civil rights rules and talk a little bit about a recent article I read in Health Affairs, which said that the new rules no longer require the use of video remote interpreting, or VRI, to communicate with patients who are limited English proficient. Well, there are a lot of problems with that particular part of the article. One of the main ones being no federal law requires any specific form of technology to communicate with any patient at any one time. Instead, the law requires the use of technology, whether it's an over-the-phone interpreter, video remote interpreting, or an in-person interpreter, that best fits circumstances, that fits the needs of the patient and the needs of the communication. The longer the communication, the more complex it is, the more important use of technology or an individual in person to ensure the communication is effective with the patient and to give the patient meaningful access to healthcare. So it is just not true that the new rules no longer require it, because no rule requires it. The new rules do, however, say that video remote interpreting, when used for spoken language, must meet certain audio requirements, that the transmission be clear, for example, and the voices can be understood. The new rules eliminated the previous requirement that the same standards be applied to video. For people with spoken language. Now, for spoken language of people who need assistance in Japanese, French, German, for example, that be given, that there are rules governing the use of VRI for the ensuring that audio, the voices, are clear. But I think what's also really important to remember, there are years and years and years worth of guidance and really good information to follow about how exactly to communicate with people who need assistance in other languages and also comply with the law. But it is just not true that the current rules don't require something that was never required. So please keep that in mind. Also, as you may know, a federal court has blocked the new rules concerning discrimination based on sex from going into effect. There may be other court decisions that implicate other parts of the healthcare civil rights rules, known as the Section 1557 regulations under the Affordable Care Act. Well, I hope this has been helpful. I look forward to our next conversation about these rules. Please stay safe, stay well. I look forward to talking to you in the future. Thank you, and good afternoon.